Tonight, there's a new legal victory for Donald Trump in his Georgia election interference case. An appeals court agreed today to hear Trump's argument that Fulton County District Attorney Fani Willis should be disqualified over her romance with her former special prosecutor Nathan Wade. Wade agreed to step down. The appeals court will now consider whether Willis should continue on with the case. Joining us now is former Georgia RICO attorney Chris Timmons. Chris, thank you so much for your time. The Fulton County DA's office declined to comment to ABC News. You know the Georgia legal system very well. Does this appeals court ruling put the case in jeopardy?
It does, Linsey, and I think that's because of the timing of it. We're looking at probably at least 6 months before we get a ruling from the Georgia Court of Appeals. I've spoken with constitutional law professors. They indicated that the Georgia case can't go forward if the former president is elected to this presidency. So, yeah, the case is in real jeopardy, and it could end, with the former president taking office. It could also be in jeopardy if the Court of Appeals disagrees with Judge McAfee and decides that, disqualification of Fani Willis and her office are a problem. That puts the case in a little bit of a prosecutorial limbo, and we don't know exactly what's going to happen from there. So to answer your question, yes, the case is in real jeopardy. This is a major roadblock.
I want to play a portion of our exclusive interview with former Fulton County Special Prosecutor Nathan Wade. Let's take a listen.
So you said you didn't want to violate the public's trust. I'm curious, do you think that you've done any kind of damage to this case?
None at all. None at all.
Even the public perception of it?
My private life became the focal point of the case. And my private life has nothing to do with the merits of that prosecution.
If you were prosecuting this case, how would you feel about a former prosecutor talking about the case?
Yeah, not great that he did the interview. I mean, certainly when you're a prosecutor, you want your pleadings to be what's speaking for you, not a former prosecutor. But in terms of what he said, in terms of not hurting the case, he's right in that it doesn't change the facts of the case, but he's wrong in that, his actions caused this case to have to we're now in a morass that started back in January when the motion was filed to disqualify him, and the case isn't moving forward as a result of that. So now we've got another 6-month hurdle here. If that relationship had never happened, we wouldn't be in this position, Linsey.
So you call it a 6-month hurdle. I'm curious, do you think that this case has any chance to go to trial before the election? And had this not happened, do you think that it would have for sure gone before the election?
It's not going to happen before the election, Linsey. There's no way that the Court of Appeals is going to rule by then. I mean, even under an expedited scenario, I still think it's going to be 6 months. And on top of that, would that relationship not have happened had this appeal not been filed? Yeah, I think we would have been, I think Judge McAfee would have issued a ruling that would have allowed the case to go forward in August. So I have some concerns. I mean, there is a chance that the Court of Appeals decides to rule quickly, but I don't think so. I think they're going to take the full 6 months that they have to render an opinion. By that time, we're in May at this point. That puts us in November. So there's no way they can get a trial started that quickly when the case isn't even going to be back from the Court of Appeals until then.
All right, Chris Timmons, really appreciate your expertise. Thanks so much for joining us.